Good afternoon and welcome to our webinar today, the first in a series that will explore the life cycle of a contract, from formation to termination and everything in between. Before we start the webinar, we have a few small housekeeping points. Firstly, to keep background noise down, we've placed each of you on mute. However, you can use the chat function throughout the presentation to post any questions that you might have, and we'll pick these up at the end. We've tried to make this webinar as interactive as possible, so please do join in and use the voting buttons when we prompt you. Your speakers today are Ben Pilbrow and me, Katie Logan. Ben and I are senior associates in the commercial disputes team in our London office, and we regularly advise on contractual disputes of varying natures and scale. Usually when a contract comes to us, it's because there's a problem with it. This means we're well placed to discuss both how to deal with contracts when there are disputes, but also, importantly, how you can take steps to prevent disputes from arising in the first place.
As Katie mentioned, this is the first webinar in a wider series, The Life Cycle of a Contract. In this webinar, we are going to look at the birth of a contract, or in rather less metaphorical terms, contract formation. Later webinars will look at the teenage problem years, considering how to address potential challenges that arise as performance of a contract progresses. Divorce, when the honeymoon period is over and one party wishes to terminate a contract by force. We'll look at what breaches of contract allow for such termination. And finally, death and estate planning, or in other words, how to plan for the demise of a contract. We've put the dates of all of these webinars on the screen now. Hopefully you can join us at them. Today, we'll start with a quick refresher of the basics of contract formation. We'll then go on to address 3 recent cases which focus on distinct areas of contract formation, and as we go along, we will highlight any practical tips in the focus areas, either emerging from the case law or more generally. We hope that these practical tips are relevant for anyone involved in advising on contract law or entering into contracts on behalf of a business. Contracts really form the basis of all business, so we hope that this will assist you irrespective of the size or nature of your business. At the end, we should have time to answer any questions. So let's get started with a quick refresher of the basics. What do you need for a contract to be formed? The following key elements must be present. There must be an offer, which means a promise made by one party to another to enter into a contract on certain terms. That offer must have certainty of terms. It cannot be vague or ambiguous, or omit some essential term. You must then have acceptance, an assent to the offer which must be final and unqualified. The agreement between the parties must include consideration, which can be anything of value exchanged by the parties. And finally, there must be mutual intention to create a legally binding agreement. It sounds simple, and it can be simple. However, we're going to consider 3 recent cases that illustrate how easily the lines can become blurred in commercial dealings. The specific elements we'll focus on through these 3 cases are, firstly, offer, and more practically how to incorporate standard terms into a contract. Secondly, we'll look at acceptance and how one can prescribe modes of acceptance. And we'll finish by considering intention to create legal relations, and in particular, where this area can become blurred in relation to pre-contractual documents.
An offer is a promise to one party to enter into a contract on certain terms. It must be specific, complete, capable of acceptance, and made with the intention of being bound by exceptions. Therefore, an offer must contain the basic terms of the agreement and evidence of an intention that no further bargaining is to take place. An offer must be complete. It needs to contain all the information intended to form part of the contract. In commercial practice, it's common for parties to make offers that incorporate their standard terms and conditions by reference. When both parties attempt to incorporate their standard terms, this can lead to something known as the battle of the forms. Business A makes the first offer on its terms and conditions. Business B then purports to accept the offer, but on the basis of its standard terms and conditions. In this situation, whose terms have been incorporated into the contract? The general rule is that the last shot fired is the one that wins. So in this simple example, these terms would apply. Importantly, a party seeking to incorporate its standard terms and conditions must do what is reasonably necessary to bring them to the other party's attention and must make it clear that it is intending to rely on them. Let's turn now to our first case, Transformers and Rectifiers and Needs Limited, where the court had to consider one such battle of the forms. We'll consider which party's standard terms were incorporated into the final contract. The facts of the case are as follows. Transformers and Rectifiers was the buyer and Needs was the seller in a series of contracts stretching back around 20 years. Problems arose with regard to two specific contracts from 2012 and 2013, whereby the seller supplied goods in the form of gaskets to the buyer. The buyer claimed that the gaskets supplied by the seller were not fit for purpose and not in accordance with the contract. In response, the seller asserted that its liability was limited or excluded by its own terms and conditions, and that the applicable terms and conditions to the contracts were its standard T's and C's because it had referred to them when it acknowledged the buyer's order. The buyer had no regular pattern in terms of how it placed purchase orders, although it placed them on a weekly basis. Sometimes it placed orders by post, but often by email and sometimes by fax. On the front of its purchase order were the details of the order, and on the reverse were its terms and conditions. The terms and conditions were included, therefore, when the order was made by post, but the buyer often sent orders by fax and email, and when it did this, it regularly failed to include them, presumably because somebody in the office had not pressed the correct button to copy or scan a double-sided document. For the two contracts under dispute in this claim, the buyer had served the purchase orders by email and fax and had failed to include the terms and conditions. Notwithstanding this, in the proceedings, the seller did accept that it was aware of and had seen the buyer's terms and conditions. The seller responded to the receipt of the purchase order by sending an acknowledgement of order. At the bottom of the acknowledgement were the words, "The quote prices and deliveries are subject to our normal terms and conditions of sale, brackets, copies available on request, close brackets." The seller, however, never provided the buyer with its terms and conditions, nor did the buyer ask to see them. The seller said that this amounted to a counter-offer which was accepted when the buyer accepted delivery of the goods. When the seller delivered the goods, it included a delivery note on which there was a standard form certificate of conformity stating, "We hereby certify that the goods have been inspected in accordance with the requirements of the conditions and requirements of the contract/purchase order." As a result of the words purchase order, the buyer said that the seller's delivery was not consistent with the seller's submission that it had accepted the buyer's order on the basis of its own terms and conditions. So, to recap, the buyer's order was placed by various methods, such as by post, fax and email. The buyer's terms and conditions were on the reverse of the purchase order. The buyer sometimes omitted these from emails and faxes, but the seller knew and had seen the buyer's terms and conditions. The seller's acknowledgement of order stipulated that contract would incorporate its own terms and conditions. The seller never provided them to the buyer, but it stated that they were available on request, and the seller's certificate of conformity referred to the buyer's terms. So, now for an interactive part. Whose standard terms were incorporated into the final contract? The buyer's, the seller's, or neither's? On the right-hand side of your screen, there is now a poll. Please vote and then press the Submit button at the bottom right-hand corner of your screen. Let's look at what the court said now. Well, in respect of the buyer's case, the court identified a problem with the buyer's different methods of placing orders. Although it sent the orders from time to time by post, in which case the terms and conditions were included, and even though the seller admitted it was aware of the terms and conditions, the court said that because the buyer didn't follow a consistent practice of enclosing them with every purchase order, it had not made it clear to the seller that it was seeking to rely on them. Therefore, the buyer had not done what was necessary in order to incorporate its T's and C's into the contract. Turning to the seller's case, the court found that the seller had taken no steps to provide the buyer with a copy of its terms and conditions, and had therefore failed to give reasonable notice of them. The court said that incorporating the terms by reference might have been acceptable had the terms the seller sought to incorporate been some standard set of terms that were routinely applied, for example those of a particular trade association. However, the terms and conditions the seller sought to rely on were its own, and therefore it was under a higher obligation to bring them to the buyer's attention in order for them to be incorporated into the contract. So the court said the seller hadn't done enough to draw its terms and conditions to the attention of the buyer, and so the seller's terms and conditions weren't included either. Therefore, perhaps surprisingly, the court found that the answer was C, neither. Neither party had done what was necessary to incorporate its T's and C's into the contract. So the position was governed instead by the implied terms in the Sale of Goods Act 1979, and so, for example, liability could neither be excluded nor limited. What lessons can we learn from this case? Well, firstly, we learn that litigation is inherently risky. If asked to advise either the buyer or seller before trial in this matter, like 90% of you today, many solicitors would not have predicted that the court's answer would be C. With regard to contract formation specifically, some practical tips. If you're attempting to incorporate your terms and conditions into a contract, make sure the other party has the opportunity to read them. When transmitting documents electronically, ensure that pages are not omitted. And for completeness, always include your T's and C's, even if the other party has seen them before. It's a case of better safe than sorry. Similar principles apply to the incorporation of terms in website trading. The website owner must draw its terms and conditions to the attention of the visitor before a contract is concluded. For example, a visitor to the site may be unable to proceed further without being forced to click a button accepting the terms and conditions, with a link to the terms being available nearby. What about the incorporation of online terms into an offline contract? For example, including wording in your offer or counter-offer such as, "This offer is subject to our terms and conditions which are available on our website." Generally, this wording seems to be acceptable for incorporation to be effective. In the case of Impala Warehousing and Wangshan Resources, the High Court found that by referring the other party to its terms on its website, the defendant had done what was reasonably sufficient to give notice of the terms. The judge at first instance said that in this day and age when standard terms are frequently to be found on websites, I consider that reference to the website is a sufficient incorporation of the terms to be found on the website. With this in mind, it seems surprising that by making its terms available on request, the seller in the case we looked at just now was not deemed to have done enough to incorporate its terms, when we see that incorporation by reference to a website has been found to be acceptable. The two cases were heard within a month of each other. Perhaps this acts to emphasise our third point: it's better to be safe than sorry. So when in doubt, it's probably better to include the terms if possible. If you find yourself in the unfortunate position of having your contract before the court's decision is unpredictable, and you want to feel comfortable that you've done everything you can to give notice of your terms to the other party so that they're incorporated.
The battle of the forms, such as in the case we have just discussed, is a more complex way of forming a contract. The usual way of forming a binding contract, if we think back to our quick refresher, is the traditional process of offer followed by acceptance. However, this is not to say that acceptance is simple in itself. It can be straightforward, but there may be grey areas when it is not entirely clear whether an offer has been accepted, and indeed, on occasions where you may accept an offer unwittingly. To recap, acceptance must be a final and unqualified assent to an offer. It is made in response to an offer, and, to be effective in creating an enforceable contract, it must correspond exactly with the terms of the offer, with no variation of the terms. Now, let's consider our second case, Reveille Independent and Anatech International, where the question in dispute was whether a binding contract had been formed. The parties were in disagreement as to whether there had been acceptance. The facts of this case are fairly interesting. Revey Independent was a US corporation producing TV programs, including MasterChef US. Anatech International was part of a group which manufactured and marketed home cookware utensils under the name the Cookware Company. For ease, we'll refer to them as the TV producer and the Cookware Company. The disputed contract provided that the TV producer would integrate and promote the Cookware Company's products in 3 episodes of Season 2 of MasterChef US, and that the Cookware Company would be licensed to use the MasterChef brand on its products for sale in the US and Canada. It was envisaged that in order to arrive at a contract, there would be an initial short-form document, a deal memo, followed by further negotiations and the finalizing of a long-form agreement. On the 16th of February 2011, the TV producer sent a deal memo to Mr. Stevens of the Cookware Company, the first offer between the parties. The deal memo was in the TV producer's standard form. Page 3 of the deal memo specified that this merchandising deal memo shall not be binding on the TV producer until executed by both parties. On the 23rd of February, the Cookware Company amended the deal memo and returned it to the TV producer. Clearly, this was a counteroffer. After some internal discussions, the TV producer sent a revised deal memo to the Cookware Company on the 24th of February. Again, on any analysis, this constituted a further counteroffer. Finally, on the 28th of February, the Cookware Company signed the revised deal memo and returned it to the TV producer. At this point, we have the Cookware Company accepting, finally and without qualification, an offer from the TV producer. Usually, as we've discussed, acceptance of an offer constitutes a binding contract. However, in this case, there was the added complication of the specification that the deal memo would not be binding until both parties had signed it. As you've probably guessed, the TV producer did not sign the deal memo. In early March, however, it produced the relevant episodes of MasterChef using the Cookware Company's products in the episodes. Meanwhile, the parties started negotiations on the long-form integrating and merchandising agreements. The negotiations broke down and were never completed. Therefore, there was no long-form agreement, only the deal memo, which was unsigned by the TV producer. A few months later, the TV producer invoiced the Cookware Company. The Cookware Company refused to pay, and the following year, the TV producer wrote to the Cookware Company, treating the contract as repudiated. The Cookware Company objected to this because they claimed that a binding contract had never been made. The deal memo specified that there was no contract until it was signed by both parties. The TV producer had not signed the deal memo, and so they argued that they could not have breached a contract that did not exist. In response, the TV producer stated that they had waived the condition to sign the revised deal memo. Their conduct in performing their obligations under the deal memo showed that a contract had been created. The Cookware Company argued that nothing could be clearer than the express provision of the deal memo about signature. With regards to the TV producer's conduct, i.e., that they had incorporated the products into their episodes and allowed the licensing, this could be explained as conduct in anticipation of a contract being subsequently entered. So, question number 2. Was there a binding contract in place? Again, please place your votes, yes or no, using the polling on the right-hand side of your screen. So, let's have a look at the response. About 55% of you said that there was a contract on the basis of the deal memo, and about 45% said that there wasn't. What was the result? What was the actual result? Both the Court of First Instance and the Court of Appeal agreed with the TV producer. A binding contract had been formed. In not signing, the TV producer as offeree was waiving a prescribed mode of acceptance. This prescribed mode of acceptance had been set out for the benefit of the TV producer. The court considered that the prejudice the contract caused to the parties. The only prejudice caused to the Cookware Company was the commercial uncertainty as to whether the deal memo was binding or not. That prejudice was alleviated, wholly or partially, by the fact that the TV producer had performed its obligations under the contract. It also paled into insignificance compared with the prejudice that the TV producer would suffer if there was no contract. The court considered that there were clear and unequivocal acts on the part of the TV producer, about which the cookware company was well aware, to constitute acceptance. Not only did the TV producer act as though bound, the cookware company also received and enjoyed the benefit of cookware company's performance, and represented itself as the licensee of the MasterChef brand. Of course, there is another way of analysing this decision. Instead of characterising the term in the deal memo as a prescribed method to accept the offer, you could describe it as a statement confirming that the parties did not intend to enter into legal relations before the occurrence of a specified event, namely both parties signing the deal memo. Such a conclusion would reflect the usual analysis of the effect of memorandums of understanding. Obviously, whichever analysis you prefer, the result would still be the same. If you thought the clause indicated that the parties did not intend to create legal relations before both parties had signed, it is clear from their conduct that they changed their positions. The TV producer by performing its obligations, and the cookware company by accepting that performance. This alternative analysis leads us nicely into our next area of focus. Before we move on, however, let's look at what practical lessons this case teaches us. It should remind us to be conscious of our conduct when engaging in contractual discussions. Even if a specific mode of acceptance is prescribed, this can be waived by conduct. Examples of where conduct could amount to acceptance would be accepting goods or allowing workmen on site before a contract is concluded. Another general tip on acceptance would be not to accept a contract to get a particular transaction or project underway. As soon as an offer is accepted, there is a binding contract in place.
The third and final element we're going to look at today is the requirement that parties had the intention to create legal relations. A contract cannot be made without a mutual intention to create a legally binding arrangement. Where there was no such intention, there is no contract. It is important to note that in commercial situations, an intention to create legal relations is presumed. This presumption of intention is rebuttable, and a party attempting to rebut the presumption has to provide clear evidence that either there was never any intention to create legal relations, or there was no intention at a particular moment to create legal relations, for example, because there remained outstanding matters to be settled. In practice, this element of intention can sometimes become blurred by the use of pre-contractual documents. It's not uncommon for businesses to draw up such documents, heads of terms, memoranda of understanding, heads of agreement and letters of intent, for example. Typically, these pre-contractual documents lay out the terms to which the parties wish to agree, the terms on which they envisage a more detailed contract being built. The heads of terms, for example, are then passed to lawyers who engaged in detailed negotiations and ultimately draw up a formal, long-form contract. Let's consider our final case of today, New Media Holding Company and Ivan Kuznetsov, where there was disagreement as to whether a pre-contractual document, called a term sheet, was intended to create legal relations, and therefore whether it gave rise to legally enforceable rights. Mr. Vladimir Guzinski and Mr. Ivan Kuznetsov were both investors in a joint venture company called SIA Energocom. This company operated in the atomic energy sector in Ukraine. On 27th January 2010, Mr. Guzinski and Mr. Kuznetsov, whom for ease we'll call G and K, signed a document which they called the term sheet. It had been prepared by the parties' lawyers. Its preamble stated that it was a document describing principal terms and conditions of company share management and control. It also stated that G held a 16.6% share in the company. In fact, at this point he didn't. His actual share amounted to something more like 5.5%. The term sheet also provided that G could serve a notice of redemption on K, requiring K to purchase G's shares. No final long-form agreement was negotiated or put in place. When G came to serve notice, K refused to purchase the shares, contending there was no right, no right of redemption because the term sheet was never intended to be legally binding. Alternatively, he argued that there was no consideration, but it was the first point which is of interest today, so we're only going to address this one here. In arguing that there had been no intention to create a legally binding agreement, Kay drew attention to several points which we've listed on the slide. Firstly, the language of the term sheet. It was named a term sheet for starters. The preamble claimed to describe only principle and not full terms. The document was brief and didn't refer to consideration. Secondly, Kay asserted that the deal memo had been signed in a casual and informal way. He thought it was no more than an informal protocol of understanding. Kay also pointed out that other shareholders weren't parties, so certain rights were not capable of being enforced without further formalities. And finally, with regard to G's stated shareholding, G was not in fact a registered shareholder and did not own 16.6% at the date the term sheet was signed. This meant that his immediate right to redeem the company's share was incapable of enforcement, and this remained the position for the following 9 months. So our final question for you today: was there the requisite intention for a binding contract to exist? Please vote yes or no now. Well, the court accepted that there were some factors which pointed against an intention to create legal relations, but the court in fact concluded that the parties had intended the term sheet to be legally binding. 60% of you came to the same conclusion as the court. So why did the court and you decide this? The court recognised that the phrase term sheet is often used in a commercial context to describe a framework agreement or template to be used to develop a more detailed legal document, but said there was no absolute rule that documents described as term sheets are framework documents only and cannot be contractual. The language of the term sheet was, the court said, fairly certain and contained certain clauses typical of contracts, and there was no indication that it didn't reflect the discussions of G and K. The court also placed weight on the fact that the term sheet had been drafted by lawyers and signed by G and K. There were no further negotiations following on from the term sheet. The court considered that this supported the view that the parties already considered the term sheet to be binding. Also, it's worth mentioning that the parties had a pre-existing contractual relationship, and this created a presumption that they intended to create legal relations when entering into an agreement. Importantly, though, the court highlighted that the question of what was intended should be viewed objectively. In other words, from the viewpoint of a reasonable and neutral outside observer. And it considered that an objective appraisal of the words and conduct of the two experienced men led to the conclusion that they did not intend agreement of any other terms, and therefore there had been the requisite intention to create legal relations. This case doesn't address novel issues. There have been many such cases which deal with pre-contractual documents and the question of intention. Sometimes such documents can be viewed as merely pre-contractual and non-binding, and at other times, as in the case we've just discussed, they do actually create a contract without one or both parties realising it. The key practical tip to come out of this case, therefore, is always to act with caution when using pre-contractual documents. Remember that if it comes down to it, a court will not ask whether you actually intended a contract to be formed, but whether objectively it could be said that there was the requisite intention. Take great care then to emphasise that a document isn't intended to create legal relations. Label it as being subject to contract. The phrase subject to contract creates a strong presumption that there's no intention to create legal relations. Do not act on the heads of terms or similar document without taking steps to put in place a further agreement. The court in the case we've just discussed said that the fact that no negotiations followed the preparation of the term sheet suggested that the parties intended the term sheet to be binding. Always make sure that you put in place a long-form agreement if there are any details that you want to flesh out or insert.
So that finishes our webinar today. You have an opportunity to put any questions you might want. So we have one here. Would putting subject to contract have meant that no contract was formed in the last case we looked at? Katie, what do you think?
I think that subject to contract is does have force, it creates a very strong presumption. It isn't bomb-proof, but it does create a very strong presumption, so I do think that might have tipped the balance in this case.
Yeah, I'd agree. Do we have any other questions? Well, whilst you're taking the opportunity to type any out, I would just take the opportunity to remind you that this is the first webinar in a series of 4, so please do log on to the later webinars where we'll explore concerns or issues which may arise into later on in a contractual relationship. The next in our life cycle of contract series will take place on the 22nd of February. There are also a number of other webinars series being run by Shepard and Wedderburn at the moment, including 2 in February discussing the top 5 construction cases of 2016 and the top 5 adjudication cases of 2016. If you'd like to find out more about these or to catch up on previous series, the link to our webpage is on the screen now. And none of you have taken the opportunity to type us any more questions, so with that we'll say thank you very much and see you next time.
Thank you.